College professors panic. New intellectual diversity law can fire them all. A new Indiana law requires public university professors to promote intellectual diversity or face potential discipline, including termination, even for tenured faculty. Tenured faculty refers to professors or academic staff members who've been granted tenure, a permanent and secure position at a university or a college. Well, it's not so permanent anymore, especially in Indiana. The purpose of the new law is to get more conservative viewpoints on campus, connecting faculty job status to their promotion of free inquiry and free expression. Critics argue that the law infringes on academic freedom, labeling it as government overreach and thought policing. Well, it is thought policing, and it is government reach. It shouldn't even be necessary, but the professors are so out of control and so one-sided and so focused on eliminating the enemies of their woke ideology that it's actually necessary. The law is effective as of now, and college professors are completely losing it. It also mandates regular reviews of tenured faculty and allows complaints from students or employees about noncompliance. So if you say something inappropriate in front of a student can file a complaint against you, and it looks like it's going to get reviewed and taken seriously. Other employees, other faculty. Anyone who hears or sees something inappropriate in a classroom come from a professor can file a complaint. Supporters are justifying the law by citing declining Republican confidence in higher education and recent controversies over anti-Semitism on campuses. And Republicans, just like Democrats or independents, do have a right to an opinion. If they feel like colleges and universities aren't representing their views, especially if they can demonstrate it, why shouldn't there be some action from the government to correct it? From Inside Higher Ed, Indiana argues professors lack First Amendment rights in public classrooms. Defending a new law requiring intellectual diversity from professors, the Indiana Attorney General echoes Florida and asserts that curriculum of a public university is government speech. And that's a fascinating constitutional question. Are you an individual when you're a professor and you're doing a job on behalf of the government? Is a police officer an individual, or are they an instrument of the government? The state of Indiana is saying, yeah, you're an individual doing a job on behalf of the government. Your speech does need to be government-approved speech. Fundamentally, I like everybody to have First Amendment rights. But if you're speaking on behalf of the government and you're only telling a one-sided view of history and race relations and what's right and what's wrong, and you're doing it to a captive audience of students that are forced to accept your ideas because they don't hear alternatives, and they're also graded, and their future depends on them espousing essentially your same views as a professor funded by the government? None of this should be necessary because people generally have common sense. But these professors, these people pushing this ideology, no longer possess common sense or a general decency or concern for other people's views. Notice in Indiana, they're not saying you need to tell one side of the story. You need to tell the Republican view, and that's all you're allowed to say because you're part of the government. You need to speak with consistent American values based on our Constitution. They're not saying that. They're just saying you can't just tell one side and push one side. In February, Republican lawmakers in Indiana passed a law saying public colleges and universities must deny tenure to professors who are, quote, unlikely to foster intellectual diversity. The legislators left it to the university trustees, many of whom are appointed by the governor, to determine what intellectual diversity actually means for faculty members and whether they have provided it. And those tenured positions are like your pre-retirement positions. You get to say whatever you want. You get to do whatever you want. You can't be fired except for cause. But that's kind of all changed now in Indiana if you work for a public college or a public university. Professors who earned tenure before the law's passage aren't spared from its implications. The statute says that whether they fostered intellectual diversity and whether they introduced students to scholarly works from a variety of political or ideological frameworks will now be considered in post-tenure reviews required every 5 weeks. Every 5 weeks? This is a really aggressive law. I could see maybe once a year, but every 5 weeks puts these professors in a box that they cannot get out of. And if you upset the people who are reviewing you every 5 weeks, they may not bounce you after 5 weeks, but they might bounce you in another 5 weeks. They really are being held to a very short leash. A bad review could mean losing both tenure and employment, as well as pension. These professors are going into schools and they're pushing their ideological agendas and they're pleasing themselves and they're trying to impress their friends, and they're doing all of that because they assume, hey, we're going to keep getting paid while we do this, right? We're going to still have tenure, right? We're going to have a nice pension to retire on, right? Well, maybe not anymore. If this law isn't overturned, these professors are going to have to do their actual jobs. In May, 4 faculty members from Indiana and Purdue University campuses sued to invalidate those parts of the law. The American Civil Liberties Union of Indiana, representing them, wrote in the lawsuit that these provisions impinge upon their First Amendment right to academic freedom to determine the content of and deliver their instruction free from interference by the state. But Indiana's Attorney General, Republican Todd Rocketa, argues that the professors have no such First Amendment right. In an echo of Florida's ongoing defense of its own legislative attempts to regulate public university classrooms, Rocketa's office wrote in a brief to the federal court that, quote, the classroom curriculum of a public university is government speech set in accordance with state law. The curriculum used in state universities and instruction offered by state employees is state speech. The Attorney General's office wrote, and plaintiffs, the professors, have no right to control how the state speaks. This is interesting. Do you have free speech when you work for a company? Can you just say whatever you want when you work for a company? When you represent that company, you put that company's jacket on with its logo? Get behind a desk, you answer the phone, ABC Company, that's you, you represent that company. Can you just say whatever you want to their customers, to strangers, to their vendors? You kind of can't. Is it different when you're working for the state? It may be, it may not be. Is it different when you're a professor and you supposedly have academic freedom? Yes, but no, not when you're speaking on behalf of the state. When a college professor talks who is employed by the state, they are speaking the words of the state. And that's the Attorney General's argument. The state says the professors are claiming a brand new state university-specific First Amendment right to academic freedom. But that last line is one of the gratuitous stupidities in the Attorney General's brief, wrote Steve Sanders, an Indiana University at Bloomington law professor who's not involved in the case. The U.S. Supreme Court recognized decades ago that the First Amendment protects public university professors' academic freedom. In 1967, the majority found that academic freedom is a special concern of the First Amendment, which does not tolerate laws that cast a pall of orthodoxy over the classroom. Attorneys in and outside of the Indiana case say court precedent cuts against the argument that Rocketa is making. In 2006, the U.S. Supreme Court handed down a ruling that curtailed public employees' free speech. In a case called Garcetti versus Ceballos, the majority ruled that when public employees make statements pursuant to their official duties, the employees are not speaking as citizens for First Amendment purposes, and the Constitution does not insulate their communications from employer discipline. Because they speak on behalf of the government. You're actually and literally speaking on behalf of the government. So if all of the professors decided they would get together and only speak one sort of message, there would be no recourse against them if they're tenured? That doesn't really make sense. While the case didn't deal with an educator, but with a Los Angeles deputy district attorney who alleged he was retaliated against for his speech, it raised the question about what seemed to be a settled legal matter. Do professors have First Amendment rights in public classrooms? It was a question the Supreme Court majority didn't get into. Justice David Souter, in a dissent joined by Justices Ruth Bader Ginsburg and John Paul Stevens, wrote that, quote, I have to hope that today's majority does not mean to imperil First Amendment protection of academic freedom in public colleges and universities. Right, because that's how they push their agenda. It's one side against the other, and one side is extremely aggressive and the other side is just on the defensive. Justice Anthony Kennedy, writing for the court's majority, responded to that dissent, saying it wasn't deciding in the Garcetti ruling, quote, whether the analysis we conduct today would apply in the same manner to a case involving speech related to scholarship or teaching. Nonetheless, Rakata's office wrote in its brief, quote, that any speech pursuant to the teacher's official duties and professional responsibilities is subject to state direction, and it cited Garcetti to back this up. They certainly should be citing Garcetti to back this up, even though they didn't answer this exact question. It's a great reference to make the state's case. The Supreme Court directly did say you don't have the same First Amendment rights when you're an employee of the government. Souter's hope seems to have stayed alive, at least so far. Greg Harold Grubel, a senior attorney for the Foundation for Individual Rights and Expression, a free speech advocacy group, said that since the Garcetti case, every federal circuit court that has taken up the question of whether the First Amendment protects speech in public universities related to teaching or scholarship has found the same. Yes, it does. That includes judges in the 2nd, 4th, 5th, 6th, and 9th circuits, according to Grubel. I would expect this is going to go to the Supreme Court, and that the law is going to stay in force at least until the Supreme Court decides. Erwin Chemerinsky, dean of the University of California at Berkeley School of Law, wrote in an email, quote, the law is uncertain here. The Court of Appeals for the Ninth Circuit expressly rejected the argument made by the Indiana and Florida Attorney Generals a decade ago. Still, Chemerinsky said, it's unknown what the Supreme Court will do, but there are Supreme Court cases expressly protecting academic freedom under the First Amendment, and this would be inconsistent with that. Yes, but those are older and older and older cases, and they refer to a time and a culture where there weren't so many anti-Americans poisoning the minds of college students. And if you're going to poison the minds of college students and force them to accept your ideas through assignments in your classrooms that you get to grade and judge them based on, it becomes a different situation. Additionally, you have the Garcetti ruling, which was within the last 20 years. Those other cases are like much, much older cases going all the way back to the 1960s. But with state legislatures pushing bills, quote, intruding upon how professors teach certain things, Grubel said he thinks lawyers will continue to make the argument, as attorneys representing both states of Florida and Indiana have done, that public university professors' speech is government speech. Quote, I do feel like it will continue until it's either taken up by the Supreme Court and they settle this, or every circuit court decides it, he said. In the 11th Circuit, Grubel himself is representing some of the plaintiffs in the Florida lawsuit that's trying to permanently stop the Stop Woke Act. That 2022 law, passed by Florida Republican lawmakers and signed by Governor Ron DeSantis, limits the way that public university faculty members can teach about race and gender. Florida students and faculty members have so far won and maintain a preliminary injunction that's blocking the act from impacting the state's universities. Oral arguments in June made clear the act's possible impact if they lose. An appeals court judge asked an attorney representing Florida, quote, could a legislature prohibit professors from saying anything negative about a current gubernatorial administration? The lawyer replied, quote, I think, Your Honor, yes, because in the classroom, the professor's speech is the government's speech, and the government can restrict professors. If such arguments prevail, Grubel said, it would magically turn professors from experts in their own fields to mouthpieces of the state. There are extreme cases on every side. Should a professor be able to criticize the government? I guess they should. I don't see why not. The problem is we shouldn't have to even be asking these questions. You do need extreme guardrails on these people because they're pushing one side of an anti-American agenda. It's political. It's ideological. And sometimes that's appropriate in a college course. The problem is you have to have people with some sense of reasonableness about them, and these people have no reasonableness. They're all radicals now. This is the only way to stop these radical professors. Attorney General Rakata didn't provide an interview for this article, but his office sent a statement. Quote, the manufactured fears put forth in yet another illegal lawsuit by the ACLU don't lack imagination, but the professors do lack standing to even bring this action. Our office will continue to defend in court this new law, which enables students to engage in free inquiry and ensures state universities foster diversity of thought. It is about diversity of thought. They're not insisting that you only tell one side of a political ideological question. They're saying you've got to cover both sides because you're too reliant on covering just one side. We've all seen it. It's not even a question. Sanders, the law professor, wrote in his Medium piece online that, quote, no Supreme Court decision has endorsed the government spokesman view of professors in the classroom. Not of professors just yet, because they never reviewed that question specifically. The professor continued, quote, take it to its logical conclusion, which is not the logical conclusion. This is a nonsensical extreme. It would reduce professors to ventriloquist dummies for whatever political faction happens to wield power on a university board of trustees or in the state house. And if that's not hysterical enough, check this out from local media. Indiana College intellectual diversity and tenure law goes into effect. A small group of students and faculty held a candlelight vigil last Sunday night and into the early hours of Monday at Indiana University's Sample Gates. Candles flickered late into the night as protesters mourned the loss of free speech. The vigil ended peacefully. A few hours later, classes were in session for the new academic year. The law is in effect. There is a lawsuit against it in federal court. The law deserves to stay in place. These professors have lost their minds. They're not concerned about two sides of an issue. They're only concerned about pushing their ideas on impressionable students and then holding those students to account to parrot those views back to them as if the students were ventriloquist dummies. And if the students don't do that, they may not get good grades. And if they don't get good grades, they may not pass a class. They may not be able to get their degrees. And it's not like there's one crazy professor doing this. There are many crazy professors doing this. That's why the legislature is involved. That's why the governor is involved. They're trying to fix a problem. It shouldn't be necessary to rein these people in, threaten their tenures, threaten their future careers, threaten their retirements. But it is necessary because these people are completely out of control. Let me know what you think of all this in the comments below. Always love to see your ideas. Please be sure you are subscribed to the channel. Click the bell for notifications, give me a thumbs up, and I'll see you again soon with another story. And if I don't see you, I will miss you.